Today, we have an unusual two-part conversation with a very diverse panel. We are here to have a conversation about what is publicly known as the Judicial Tribunal. The ISLA Conversations public engagement discuss topical issues related to gender justice and its intersections with education in Africa. And the purpose of these conversations are to raise awareness and to highlight a deep understanding of persistent issues like sexual harassment, gender-based violence, and the patriarchal structures in law and society. We do this in order to promote strategic litigation and to explore legal strategies for reforms and to challenge systemic inequalities that we continue to see in our country and continent. The third objective of this conversation is to facilitate public discourse, because we do believe that what happens outside of the courtroom or in accountability mechanisms just as important as what happens inside the court. So we want to create a platform for public engagement and dialogue on human rights issues, bringing together feminist lawyers and other stakeholders with the intention of shifting the public narrative and ultimately dismantling oppressive systems using the law. And finally, we believe that advocacy needs to be informed. So we have this conversation as a way of strengthening informed advocacy efforts by sharing knowledge and insights. The Mbenenge tribunal that we are talking about is a tribunal, the South African Judicial Conduct Tribunal. This is a Judicial Conduct Tribunal investigating allegations of sexual harassment against Eastern Cape High Court Judge President Selby Mbenenge. This marks the first time that a sitting judge has been formally investigated for this offense. This tribunal was convened after a complaint was filed by ISLA Conversation secretary who worked at the Eastern Cape High Court, who worked there. She alleged that Mbenenge sexually harassed her through a series of WhatsApp messages and images between June 2021 and November 2022. Mbenenge has denied the allegations, maintaining that the conversations of Mbenenge were consensual and fictitious. What is important for us in this conversation is that there are many conversations about this judicial tribunal. What we want to highlight in this conversation is the interplay between race and gender as it applies to Black women complainants, and how this plays out in the tribunals themselves and also in the public domain. We want to foreground this on intersectional discrimination, because intersectional discrimination has a framework of analysis that recognizes that different forms of oppression can coexist to produce a distinct and enhanced experience of oppression, has traveled across continents and disciplines, and it exists to inform thinking and systems. But in South Africa, we continue to see token attention being paid to these intersections. In one way, it is acknowledged that it exists, but in another way, it doesn't find itself in legal analysis, before courtrooms and spaces where Black women go seek justice. We fail to use the legal tools that are provided, including the Constitution, to capture how intersectional discrimination arises in law. But more importantly, we fail to recognize how the failure to deal with it as a necessary and urgent tool to address this systemic discrimination continues to act as a barrier for Black women seeking to access justice, because it hides the very specific forms of biases against Black women that these court processes continue to show us. So to have this conversation, it is important to revisit Kimberly Crenshaw's seminal work that told us to address this intersectionality. And this specific case allows us to draw the parallels, between the context that she was writing about and what we are seeing playing out today. The work was a call to action because it asked us to be mindful of treating race and gender as separate. She argued that this approach disadvantages Black women because they experience discrimination that comes from the intersection of both race and gender and could not be addressed by anti-discrimination law or feminist theory that only focuses on gender or race in isolation. We understand that in many countries across the world, this inability to respond to intersectional claims is entrenched in the law, in that many constitutions do not accept claims that are based on more than one ground. So victims have to either choose between race or gender or any other ground. And so that is why intersectionality remains unaddressed. The South African Constitution does not have such limitation. It recognizes that discrimination can occur on a combination of these grounds. They can intersect. So we see this in South African feminist and legal analysis, this intersectional analysis, and yet it continues to be grossly underutilized as a framework for analyzing how Black women are treated in legal proceedings and how intersectional discrimination has a role to play in the limited jurisprudence that we see on Black women's claims, particularly in gender-based violence cases. We have courts that recognize multiple discrimination when we are dealing with Muslim personal law, customary law, domestic work cases, but it is rarely applied when dealing with gender-based violence cases. Because in this aspect, even though it is recognized, the law continues to treat women as a homogeneous group by failing to look at intersectionality. The Mbenenge Tribunal has brought this to the fore, and it is really asking us to grapple with this issue. And there are many ways in which it has come about, and I'm just going to surface just two ways. The first one has been the deployment of culture as a way of explaining that in a particular context, the conduct complained of cannot be sexual harassment. In the public domain, there has been a conspiracy theory that has been brought about that cases like these are about bringing down successful and respected Black men in the legal profession. So claimants are seen to be in cahoots with the structural systemic racism that we have in South Africa, and this conspiracy theory with racists is often an enduring defense that is weaponized against Black women complainants who are then seen as traitors. To start this conversation, I would like to invite Nicolette Naylor to join us. She is a Pan-African feminist and senior philanthropic leader, works at the intersection of justice, feminism, and philanthropy. Nikki is not a new person to us. She is a friend of ISLA. We have had a number of these conversations, and more importantly, in 2018, when sexual harassment was topical, we had an ISLA conversation that talks about sexual harassment. So we are back here. Welcome.
Thank you. Thank you for having me. Thank you for having me today.
So our conversation is about sexual harassment. And I would like to start by saying why the anti-discrimination framework is a useful framework of analysis when talking about sexual harassment and join those in the source.
Thank you, Nicolette. And good afternoon, everyone. I think it's so important, and thank you for underscoring the importance of us seeing sexual harassment as an issue of discrimination, as an anti-discrimination issue, because it places it within a struggle for equality and human rights, as opposed to just looking at it as an issue of inappropriate behavior or misconduct. It's about inequality of human rights. Then it's not isolated bad behavior. 5 reasons. I think that the fact that sexual harassment talks about power imbalance, it helps us to talk about power, and recognizing it as a form of discrimination shows us that it's connected to structural inequality, not just interpersonal conflicts. So the Constitutional Court has helpfully, in the McGregor case, framed this workplace sexual harassment as an affront to dignity and equality. And I said it's the antithesis of substantive equality. And so it's explicitly linked to power relations and a substantive equality analysis. And so it signals then that how we adjudicate these cases has to look at it as a structural inequality matter. And then most anti-discrimination laws, whether it's in the US, the UK, international frameworks like CEDAW, also recognize sexual harassment as a form of sex discrimination. And that provides survivors with stronger protections and clearer avenues for redress. It's not just a workplace dispute, it's a violation of human rights. The third reason why I think it's important is because when you see it as discrimination, you can then speak about creating a hostile environment where you're preventing women, particularly Black women, from enjoying equal opportunities in the workplace and in public life. It's not just about a single moment of abuse, but it's about blocking access to opportunities. The fourth reason is that when sexual harassment is viewed through this anti-discrimination lens, then the responsibility shifts from holding individuals responsible to actually looking at institutions and systems of power. So it requires then a culture change, not just looking at an individual bad apple or an individual person that's behaving badly, but what is the institutional culture actually and can hold institutions accountable. And then the piece that you've also touched on, framing harassment as discrimination allows us to acknowledge the intersection of race, class, disability, sexuality, as other identities. So a Black woman, an LGBTQ plus worker may face harassment based on multiple grounds, not just based on sex, maybe based on sexual orientation, maybe based on disability, and it allows us to take that holistic perspective. And I think if we weren't frame harassment as a discrimination issue, it may be harder for us to do that. So to summarize, I think sexual harassment as an anti-discrimination issue really makes this about a systemic barrier to equality. And it demands of us to think about structural solutions, not just solutions around individuals. Yes, it's about holding individuals accountable, but it's about structural and institutional accountability.
So thank you for that, and I think we will return to this issue of what does it mean to hold the spaces where this sexual harassment happens and look at them as structural programs instead of just individual programs. There has been some confusion about whether judges can be held accountable using sexual harassment laws that are used in other cases. And what's the difference between this Judicial Conduct Tribunal and other ways in which sexual harassment claims are handled? Because if one was reading what is in the public domain, you would think that there's actually a shield or judges are absolved, from being held accountable. So when people hear that the laws that apply to everyone don't apply to judges, what's the distinction here?
Well, firstly, I think that's not correct that the law doesn't apply. Constitutional rights, human rights, the right to dignity and equality into a workplace and to an environment that's free of harassment applies to everyone. Now, normally sexual harassment is dealt with in the context of the workplace, but our law also has protects people from harassment on the street. Walking on the street, if you're in a pub, so public places, private places, workplaces, you are protected from sexual harassment, bullying, and other forms of discrimination. Now, most in the employment context, you usually have a code of good practice for handling sexual harassment. And so most of the cases that have come through the South African legal system have been through the CCMA and the Labour Court proceedings. And what's interesting about those cases is it's usually men challenging the fairness of their dismissal, where they've been dismissed for sexual harassment, than women bringing the cases. So those are the most cases. You also have a right to civil damages for civil cases. There've been constitutional court cases, cases based on the common law of your duty to protect people in the workplace. And so most of our legal development has been in the context of the Employment Equity Act and the Code of Good Practice. I think the Judicial Conduct Tribunal is very interesting here because the focus of a Judicial Conduct Tribunal is about investigating whether a judge has breached the Code of Conduct for judges. And you recall in the US context, we've seen this come up in the Anita Hill and Clarence Thomas case, where it was in the context of judicial appointments, whether you were fit and proper judge. Now, this Judicial Conduct Tribunal is investigating the terms of reference or investigate whether sexual harassment occurred and whether the judge is guilty of gross misconduct under Section 177 of the Constitution. And so this case is going to set a precedent in terms of seeing sexual harassment as a form of gross misconduct, firstly. But a lot of the press is talking a lot about sexual harassment versus this inquiry around whether the judge is a proper person, whether the judge has acted with impropriety. And the Code of Conduct for Judges speaks about how judges behave in public spaces, in the workplace, and in private. It doesn't only speak about your judicial conduct on the bench. And it speaks about whether you've, and so the test is whether you're going to be impeached. So this is an impeachment process and an impeachment hearing. It's not a sexual harassment hearing on its own. But the fact that it's a judicial tribunal doesn't change the definition of sexual harassment. It doesn't change the law of what constitutes sexual harassment. So for that part of the inquiry, it's not like you can say, oh, well, all the law and all the precedent on sexual harassment doesn't apply because this is a judicial tribunal. It would still apply. But there's two tests that are applied here. There's the test around sexual harassment, but there's also the test around whether the judge acted honorably in his professional life and private life, whether he's avoided impropriety and whether there's any impression of bias. And so the terms of reference have spoken about the allegations of sexual harassment and impropriety. And so for me, what's been interesting is that a lot of attention has been placed on the complainant. What did the complainant say? What did the complainant do? Versus just looking at WhatsApp messages sent from the judge that the judge accepts that he sent and testing the conduct of the judge versus testing the conduct of the complainant and saying, does this meet the standard of judicial
conduct that we expect of judicial officers. And so there's two prongs to this inquiry. And I think impropriety is also not limited to actual misconduct. When you look at judges, it's about the appearance of impropriety. So if a reasonable person could perceive a judge's behavior as being improper, and I think this case matters because it's an indictment on the judiciary. Because often you look at a judge's conduct and say, well, how would this judge then manage other cases of sexual harassment or other cases of gender-based violence? And what about the leadership role of this judge in terms of the conduct of the judge? So when argument is going to be presented, I think I'm hoping that the argument will be presented at two levels, showing that the sexual harassment occurred, but also whether there was impropriety and whether the judge is acting honorably as a judge. Those two tests have to be met, which the public hasn't really spoken about a lot. There's been a lot of focus on blaming the complainant and speaking about the complainant in very disparaging terms and cross-examining the complainant versus just looking at even what the judge concedes as, yes, I did say that in the context of a flirtation and two consenting adults.
Yeah, I guess the salacious detail of nature of the sexual harassment inquiry is also what makes it interesting, to the public. And so that's why we end up seeing such a lot of commentary. And in a context where misogyny is pervasive, the desire to pull and pick apart her case becomes stronger than trying to understand what it is that the legal process has to determine, or why this tribunal was actually kind of set up. And that's the reason why we have this conversation, to say that this is the law and this is what needs to be inquired into versus what people would like it to be. But in the tribunal itself, the emptying of what's sexual harassment about, like the gutting of the definitions of sexual harassment, and also the power imbalances that helps us to understand sexual harassment in the workplace, is deliberate because it's part of the defense, and the defense says this was consensual, this was flirtatious. And so it stands on this just being between two consenting adults. And that is also one of the things that has been of interest, to the public. So why should it matter if someone is a judge? You've got two people. This is a conversation that went on for more than a year. So why should anyone, be concerned about this conversation? But I want us to go back to the issue of race and culture, and to talk about how it has been deployed in this case, and to go back and look at how our courts, over this period of time where we have said we are putting in place normative standards to respond, legislation, policies to respond to sexual harassment, to look at how courts have navigated race, class, and gender in sexual harassment cases, particularly when it is intra-racial, incidents of sexual harassment, and how this dynamic playing out in this particular case in terms of race and culture, where we see race being weaponized to invalidate the allegation that sexual harassment has actually occurred. Because when you think about it, is the entire defense of what makes this consensual and flirtatious, and more importantly, the inability to accept that no means no. It's that it is embedded in a specific cultural context where basically Black women become unharassable, because this is how, as the judge said, many men would explain how they got married, that this one made me struggle. She didn't just say yes. in the beginning. So this is basically how you begin an intimate relationship, by resisting and then telling the other person to try harder, to get your affection, and all of that. So this is what's being put in the domain. So how have the courts navigated this issue when it comes to intraracial incidents of sexual harassment?
Well, I think the courts have not really dealt with the intersection of race and gender in cases of sexual harassment. A lot of cases, the court has been very willing to pronounce on what constitutes no. And it's been very clear, the Labour Appeal Court, around, firstly, that the workplace is not a pickup joint, that you're trying to test the waters. It's not a pub, the workplace. Our Labour Appeal Court has over and over emphasized that a relationship of supervisor and a relationship of power and authority over economic livelihoods of individuals will determine how people respond to sexual advances in the workplace. And so the way in which people say no may look very different. Someone may just walk away, but the chances of a complainant slapping you and saying no and shouting at you, if you are the supervisor who's going to do the performance appraisal and hold the power over whether your job is going to continue or not, is unlikely. So the emphasizes a contextual approach and taking a perspective from the perspective of the complainant, a survivor-centered approach. And our Labour Appeal Court has consistently said you have to look at it from the perspective of the victim. But most of the cases that have come before the court have tended to be white women, middle-class women, where the perpetrator is a black man or a manager. And the courts, this issue about believability, I think we need to interrogate more around how the court analyzes the credibility of witnesses. We had one case, the Mokona case in Tsavo, which looked at cleaners. So in terms of a class analysis and a race analysis with their supervisor, and that's the one case where the court found they didn't believe the complainant when she said that the supervisor was coming into the room and trying to look at her when she was getting undressed. Said, why would the supervisor do this? So why would this man want to look at you cleaners getting undressed? A very different analysis from a race, class, and gender perspective when you've dealt with the white secretary or PA to a manager. How we analyze and how we look at whether people are believed or not. The other issue that I just want to touch on here in terms of the conduct of the complainant in relation to back and in relation to when people, the appeal court has said on many occasions that sometimes the way in which people respond may appear that they're okay with it. They may even engage in the banter. And after a while, you may not immediately indicate, oh, and that's okay. And so the court has always said that it doesn't mean the fact that you are sending the signal that you did respond to the message, because people say, why didn't she just ignore the message? They're saying, well, there's a relationship of power. We must look at the relationship of power. But most of the decisions at the lower court level and at the CCMA level have held that against complainants or complainants. The fact that you engaged in banter for 7 years, in one case, this was going on for 7 years, and you didn't do anything. Why did you? This thing about how we think complainants should behave, it's always needed to go to the Labour Appeal Court, for the Labour Appeal Court to then intervene and say, no, this is an infringement on dignity, and power is an important thing that we have to keep analyzing. I think it's sad that the courts, when they do the power analysis, have failed to look at race and have failed to look at race and class in terms of how they treat the complainant. And this case is now forcing the Judicial Tribunal because it's been raised as a defense. This came up in the Anita Hill case where people said, well, this is just how people test the waters. This is just how people behave. And so I think it's time that we actually have some pronouncements on this, where it's raised, where culture is raised as a defense. It hasn't come up in our courts before. And so it's going to be interesting to see how this analysis plays out in this case.
So you are the people who are here to kill romance because you don't want to see romance start. This is the way that it is supposed to start.
You're coming to work. You're not coming to a pickup joint. That for me is like, oh, I'm testing the waters as a whole judge president. You testing the waters with someone who works there?
But he says he was not a direct supervisor. He was not a line manager. So this is not the person who was going to do the performance appraisal. So him being a judge president did not impact on how she responded because he was this man who was engaged in a conversation with a woman. It was a man-woman conversation. There was no judge-secretary conversation. So why are you imposing this judge-secretary kind of framework? So basically there is a pushback against this kind of power analysis. So why are we just not letting this man be a man and a woman who are starting a relationship?
Our courts have had a chance to pronounce on this in terms of, even if there's no direct supervisory relationship, you must analyze the power differential between the two people at play. And this is a judge president. There is a power differential in terms of how people are going to conduct themselves. And remember, we're now also dealing with, this is a judicial conduct inquiry. How do judges conduct themselves in the workplace? We've had cases of sexual harassment where two peers went away on a business trip and he said, do you want to love it tonight? Do you want to come to my room tonight? The court said, even though they were peers, that's sexual harassment. And that's a dismissible offense in terms of what is the culture we're trying to create in our workplaces? Is it a culture to respect the dignity of people, dignity, privacy, equality, and human rights? Or is it a culture where everyone's testing the waters for sexual favors? And I think the definition of sexual harassment also looks at the issue of quid pro quo harassment, hostile work environments, and sexual favoritism, because when you allow this kind of conduct, in some cases, the employee, so there's you harassing me, and I'm saying to HR, it's okay. I don't mind. I like it. I like it when my boss walks past and he hits me on my bum. I like it. The employer can say, that's not the culture we want in our workplace and we're going to dismiss you. Even if you saying, please don't dismiss him. I don't mind. Or the other women in the office say, we don't mind if you put up some pornographic pictures. It's okay with us. We think he's funny. An employer we have a duty to create a certain culture in the workplace. And so I worry about what is the culture we are creating in the corridors of the judiciary that has to uphold and protect women from violence. If this is a culture that the judge president is very blatant, it's not like he's denying that this happened, which would be very different. Clarence Thomas and Anita Hill, he said, she's lying, this never happened. He said, yes, I did send these messages. I'm testing the waters, Moss. Like what? Don't be a prude. And I think this has come up in the context of civil society organizations, sexual harassment. This also came up about we don't want to be prudish. We want people to have sexual autonomy and explore their sexuality in the workplace. And I think we have to grapple with that piece. Is that the cultures that we want to create around what does sexual agency look like, sexual autonomy, and cultures that are respectful of women in the workplace?
There is one incident where the judge says he told her to remove her jacket because he just wanted to see her body, structure. And would that still constitute sexual harassment?
Yes, we have a case actually where the person said, the guy in the work said, I can't wait for summer to see you strutting your stuff. And so the commissioner, the CCMA commissioner said, that's not sexual harassment. That's innuendo. I can't wait for summer to see you strutting your stuff. They said it doesn't have to be sexually explicit. And again, that had to go on appeal because the CCMA was saying, she's being hysterical. This is just someone complimenting you. Can't you just compliment people in the workplace? And the court said you're always approaching it from the perspective of the complainant. How did the complainant feel about this? Did the complainant want this or not? And you have to look at what is the culture that the employer is trying to create in the workplace. And you don't need to be sexually explicit. If a compliment is unwanted, it's unwanted. The test is whether this is unwanted sexual attention. And in some contexts, an employer may say, we don't want this sexual attention and sexual undertones permeating our workplace. And an employer can set that tone.
So before we hand over to the next panel, what do you think needs to be done for these claims of sexual harassment to surface this issue of intersectionality? Because here, it's not like the complainant went to the tribunal and said that I am subjected to intersectional discrimination, you know? And so it has to be other people who raise that, because complainants know that what happened to me, I do not like it. And so all of this analysis is basically legal kind of argument. So how do we get people to understand it, the broader public to understand that when these kind of defenses, because when you listen to the defense, that says as a Xhosa man, this is how it works. What it tells you is, if this woman was not a Xhosa woman, this is a defense that would not have war on her. So it's a defense to her claim, you know? So here it's about how do we make this visible, that it is a barrier to Black women getting justice. Because if you've got defenses that are only applicable to them, you know, that makes them unharassable or less harassable, then you do see this intersectional discrimination. And there have been quite a number of other cases, because here it's not only this defense, it's also the fact that there is a way of looking at this as an attempt to bring a Black man down. And we can come back to this when talking about the traitors, basically. So how do we make intersectional discrimination understandable in the broader public, but also encourage lawyers to actually pick up on it, you know, as a way of refuting these defenses when they come up?
I think if I want to start with lawyers, I think we have to make these arguments. The arguments can't just be on the basis of gender. We have to bring in a race analysis. And I think there's been a laziness to do that race analysis and a class analysis in cases of sexual harassment, and put those arguments before the court to force the court to grapple with it. Because the court isn't going to, on its own, of its own accord, start grappling with this. So we need lawyers to make this argument. And I think explaining, and this is a very good case to really disrupt the narrative in the public discourse around what defenses look like, this intracultural, well, this is how we behave. And if I behave like this is how I pursued my wife, why are you now behaving differently to this is just the way things are? I feel like that argument, we had an opportunity now in this tribunal to really address that, but we're having a lot of discourse around this is a political vendetta. And we've seen this with Black men in power around the world, whether it's R. Kelly, whether it's you have Bill Cosby, it's you trying to bring the Black brother down. And as Black women, solidarity means, we don't talk about this. We deal with it in our own way. Don't bring down your Black brother who is rising in the ranks. And I feel like we're having a really honest conversation about this is unacceptable conduct, and this doesn't mean a lack of solidarity or a lack of understanding that white supremacy is pervading our country and our workplaces. And you can acknowledge racism while still, both things can be true, while still holding a Black man accountable. But the moment you try and hold a black man accountable, you're seen as you buying into white supremacy. And so that's a political argument. And how do you start framing your legal arguments to deal with the politics of race and gender? And I don't think the courts can always solve for that. That's something in the public narrative that we need to start shifting. But bringing the cases before the courts and making an intersectional argument before the courts is one step to help us to get there.
Thank you very much for your time. We will be back here. So we have our second panel and we'll take questions after the second panel. Thank you very much. Are you taking this?
Thank you.
Are they playing?
It won't play on the presentation of the tweets. Presentation of the tweets. Okay, thank you. I want to introduce them first. Good afternoon, everyone. Oh, great. This can play in the background just to give you an idea of some of the vitriol and some of the commentary that's been shared on social media about the complainant, Ms. Mbenenge, just to give some of you an idea of exactly what we're dealing with in this context. I haven't introduced myself. My name is Sibusisiwe Ndlela. I'm an acting managing lawyer in the Countering Anti-Rights Actors program. It's a pleasure to be with all of you today. I'm going to be in conversation with two learned friends who I will introduce in due course. Then I will invite them to join me on stage. I will be in conversation with soon-to-be Dr. Zetsu Albany. She is a socio-legal researcher at UCT, and her doctoral research focused on examining the credibility of complainants in rape trials. Please come ahead and join me. I'm also going to be joined by Dr. Mpumi Motlafi Francis, who is a postdoctoral researcher at the University of Johannesburg. Her doctoral thesis interrogates the exclusion of Black women in the post-apartheid process during the rape reform process. Please may you join me on stage. Great. Thank you again, ladies, for joining me. And thank you, Sibongile and Nicolette, for your session. We will, as Sibongile mentioned, return to the question and answer session. But for now, I just want to engage with the two ladies who are with me. I'll start with you, Zetsu. So we began this session with some of the tweets that were displayed, intentionally so, because of the nature of the vitriol that we've seen in social media. And that vitriol has shown patterns of misogyny. It's shown patterns of undermining the credibility of Black women, and also how culture has been used against us, our culture, in fact. So for present purposes, I want to just begin by talking about the Black woman complainant in the context of court proceedings. So Zetsu, based on what you understand about the notion of the unrapeable Black woman, how do you believe that this affects Ms. Mbenge's credibility in the context particularly of these proceedings in the tribunal?
Thank you so much for having me. I think before Ms. Mbenenge even enters these proceedings, right, she's marked by this historical script of the unrapeable Black women, right? So this is a figure that is not invented in this tribunal. It is not new. This has existed for centuries. This has existed within slavery, colonialism, and even apartheid. Across regimes, Black women's bodies have always been perpetually available, right? We have always been incapable of being violated. We have always been unworthy of legal protection. right? So even before she had stepped into this, there is this figure that exists that already excludes her from being protected, already sees her as always willing to say yes, always willing to say, to welcome these unwanted advances. So she's always also treated as a suspect. As Black women, when we come forward and we report anything, we are always treated as suspect. We are not always taken and said that, okay, how do we find evidence for what has happened to you? We believe you. That is not the first thing that is said to us. Instead, it says, what did you do? What did you not say? And so this is how we see the centering of the tribunal and the conversation being about her conduct and not being about the judge's conduct, right? So the whole thing in the tribunal, even it being a judicial tribunal, is about the judge's conduct. But instead, it becomes a question of what did you do? What makes you the victim, an ideal victim, right? So she's already outside of this concept of the ideal victim. The law has long decided that the ideal victim is a white woman, right? And so because she is a Black woman, she is now outside of the script. And so she's already having to now fight through all these barriers to say, hi, see me, believe me, that this happened to me. It's already brave for you to come forward. But how much more now? There's this constant fight for you to even be taken seriously.
Thank you for that. So you're already grappling with this notion of her injured credibility, but now you're putting her against the Judge President who's leading the Eastern Cape Division. What sort of factors, like perhaps his social status, his hierarchy as a judge in the context of a court, what sort of factors do you believe insulate him as a potential perpetrator?
I mean, we must look at who he is in the public imagination, right? This is a man who is seen as well-spoken. That is something that is spoken about so evidently through every tweet. He's so eloquent, right? He's intellectual. And so he's also then seen as a decolonial hero, right? He is also seen as someone who is constantly pushing back against Western standards. And so this is a fight to take down a Black man who is doing something, who is fighting against white supremacy, right? So she is conspiring. She's a conspiring woman, right? She is part of this white monopoly capital that is brought to bring down this Black man, right? Because he is doing something that some people have not been doing. And so because he is respectable, I mean, there's even videos of him and his family going around on Twitter, on TikTok, where he's singing with his family, where he's singing, a church song. So he is now this man who has a family. He's seen as a respectable man. He's also then seen as a man of faith, right? And you see in one of the tweets where she is then the Jezebel, she is the liar. And we see this in the Omotosa trial. We see this come up also in the Zuma trial, right? Where these women are coming forward and saying that this has happened to me, but instead they are framed as these conspiring women, as these evil women. And so this is not something that is new. This is not something that we haven't seen. This is a culture that has constantly been created where Black women are not believed, where Black women are constantly having to fight this thing, where he is now credible, right? And even people in writing, they speak about his dignity, right? That we need to protect his dignity as well. We need to be protecting him. He is now framed as the victim. He is now the one who we need to be protecting. And this is why even the discourse is around what she has said and how she responded, instead of, is it appropriate for a judge to be sending such messages to his secretary? Not even his secretary, but to someone who works in his workplace.
So in your research, you've often used African feminist theories. And I wondered if it had any application in this particular context, specifically on reconceptualizing what credibility looks like for Black women. Do you have any reflections on that?
I mean, credibility doesn't have a standard right now. It's not something that is legally written down. It's something that is assessed on a case-by-case basis, but it is claimed to be neutral. It is claimed to be objective, but we know that it is not, right? But also we need to understand that credibility needs to now be situated in lived experience. The reality is that there's a lived experience, there's a power dynamic that credibility does not take into account. It takes into account demeanor, how I am seated, what I am saying, how coherent am I saying, saying it? Am I able to constantly say the same thing? Is what I've written when I reported the same thing that I'm saying when I'm being cross-examined, right? It does not take into account the fact that there is a hostility about cross-examination, that there is also a nature and a violence that you have experienced, that trauma is not something that is coherent, that is consistent, right? And so when we understand credibility, and it cannot be put forward as something that, oh, these are the checklists that we are wanting to see from you, this is what we want to see. This is something that needs to be understood as a lived experience that is always changing. Credibility starts with you as a person yourself. Before you even report, you ask yourself, will I be believed? Did this happen? Do I have the language to explain it? And I think for many something that we haven't taken into account is that when women come forward and speak about violence, they have sat with this violence themselves and asked themselves, did this happen? Was I not complicit in it? Because this is something that exists within society. So you coming forward already, there's already a fight that you have fought within yourself. Right. And then you fight another fight. And so this is a constant battlefield that you are in, where you are constantly fighting to be believed, constantly fighting to be heard. And so we need to get to a point where we see the reality that Black women go through, the reality of the situation, and actually have this intersectional approach, because we cannot keep bringing it up in theory and bringing it up in constitutional judgments, but it is not something that is happening on the ground. What is happening on a daily basis, our law needs to be it needs to be lived and no longer just be on statute.
That's quite a powerful reflection. And if you think about how Sibongile and Nicolette were speaking earlier about how our law is just not able to grapple with intersectionality. It sees different types of lines of identity as being parallel, as not intersecting. I just wanted to highlight how that gap and that non-existence of a solution in the law has created an opportunity for the logic of the manosphere to permeate the tribunal. We've seen it in the public discourse, but I just want you for a moment to reflect on how misogyny and how the logic of the manosphere have been manifested in this tribunal.
So a definition for the manosphere is basically the network, right, of influencers men who believe themselves as victims of feminism, right, who argue that women weaponize sexuality and insist that male entitlement is natural, right? And so this is misogyny, but it is seen as intellectualized, right? So it is reframed as rational debate, right? So these men and say, no, this is our side to it, right? And they're fighting back because we are fighting the patriarchy, they are fighting the feminism. And so this tribunal is saturated in this logic, right? So we take, for example, the defense saying that no means no is a Eurocentric concept. This is the manosphere at work, because this refusal, right, to legitimize her saying no is a way of fighting back to say, no, how dare you not say that, how dare you ignore the fact that I have come and give you an advance. Me advancing and even looking at you is a privilege, right? It is something that you should see and accept as something that is a gift to you. Also, it ignores that this seniority, right? It's taken away. He's not seeing himself. This power dynamic is constantly being pushed back. He's saying that it's not there. This is not something that we need to look at. It's not something that we need to take account for. I need you to focus on the fact that I am just a man who wants a woman, and a woman who clearly wanted me. And this is what he keeps fighting back to say, that she wanted me. This is why she replied. This is why it was sustained for as long as it was. Right. But also, what does it mean to reframe no means no as Eurocentric in the rape capital of the world? What does it mean to bring up rape culture as a defense? Right. So then this is also something that we need to think about, to say, what does it mean for Black women to live in a society where you are now saying that our culture has always made us available, right? Which goes back to this concept of the unrapeable Black women, right? So then it even permeates in our culture, which says that we are always available, we are always ready. You should always, be willing to accept any advances that you get, no matter how uncomfortable you are or where you are. Also, fear is something And that needs to be taken into account. I know so many of us who live, who go through harassment on a daily basis, who end up giving people your number for the sake of giving your number in spheres of not being killed, right? We live in a country where men are violent. They respond, their violence is in you saying no, your no is met with violence. And so this is also something that needs to be taken into account, that fear is something that exists and that is constantly there. So yeah.
Thank you for that. You've already started discussing it, but I'm just curious to know how that logic of the manosphere has permeated also into the commentary around the tribunal as well. Not just the cultures and the society that we live in, but the people who are propagating these things on social media, they're writing about it, they're writing op-eds about it. What can you tell us about that?
I mean, I think Advocate Gwalana's blog is the most prime example of this, where it's also the protection of the brotherhood, right? He comes into the defense of the judge, but also the advocate, where he says that his line of questioning is not hostile in any way, where he says that he's just merely doing his job, right? And he responds to feminist outrage as being overreacting. He says that this is not something that we need to take into account. You're exaggerating, you're overreaching, that this is just merely something that he positions as a rational voice against hysteria. Right. We also see this in how there's commentary that ignores the substance of harassment and instead defends his reputation. Right. Everyone keeps pushing aside this commentary to say that this is a man who is a decolonial hero who has done so much for us and that he is now trying to be taken down. This is also then how this misogyny is dressed up in intellectual debates. It's also not marked as she asked for it, right? It's not in crude ways. It is shadowed, it is polite in how it is put out, right? It is a pseudo culture that is brought up that no means no is Western. It is respectable that we must protect a good man from conspiring women. This is the manosphere's logic that women's testimonies are dismissed, men's reputations are defended under the guise of reason. So again here, race is central because the defense of a black man is now bound against colonialism and attack on black man's authority. And to defend him is to is a fight against decolonialism, right? And so to cast her and to believe her is a form of betrayal. So this is what Nicolette brought up, but we constantly need to be reminded that decolonization without gender justice is not decolonization. This is just patriarchy in new clothes. And therefore we cannot keep reproducing a system that constantly sidelines women, that does not protect women.
Thank you for that. Another way in which Black women have appeared in this tribunal is potentially the paucity of expert witnesses that could have been a Black woman. I want to turn now to you, Mpumi, for us to just talk and unpack a bit more what that actually means. So you've written an op-ed, which was published in the Mail and Guardian, and you've alluded to the fact that the choice or the resort to the particular expert witness that was called is one that was problematic or concerning. Can you perhaps just unpack why you believe that is the case?
Yes. First of all, just to clear things up before I start anywhere, I'm coming into this not as a legal expert, but as a political scientist with a background in history. So I would say as Black women and as Black people, we represent a diversity of views. So even within my networks of researchers that I engage with, we don't necessarily see things the same way. So not all of us see the choice of expert as problematic. But amongst those of us who do, it's not so much the individual that was chosen, so much as it is about the assumptions between the link between race and who is automatically considered the go-to expert when we talk about how we should interpret and determine that this is sexual violence or not, and what we should do about sexual violence. So it's something that has a long history behind it. I wrote that history in the op-ed, and it's not something that many ordinary South Africans might be aware of, but there was a development anywhere between the late 1960s into the 1980s, maybe also slightly into the 1990s. We had what is called in the West the second feminist wave. It was a time when people working on women's rights, some of them calling themselves feminists, some of them not calling themselves feminists, but highlighting this issue of sexual violence being a problem that politicians should really pay attention to, asking us to pay attention to other sexual and reproductive rights issues. So it happens visibly in the West, but then similar developments were happening in other countries, including white apartheid, racially segregated South Africa. And you must understand in this context, we were fighting apartheid, right? We can say there was a broad-based movement against apartheid. But then when these developments happen, it's white feminists who are positioned to be in institutions, and they have the resources where they can engage with all this knowledge coming from elsewhere. And they can educate themselves about what the major debates are around the issue. They are the ones that have the resources to then start the organizations like the rape crisis centers. And in that way, they position themselves as being in the forefront. So when the apartheid state starts to liberalize, and by the way, it liberalizes in a way that still excludes the Black African majority, but sort of brings in Indians and coloreds, but on the peripheries, and says, okay, let's talk about, how do we change the law? It's those white women at the forefront. And once the transition happens, it's still those people in the forefront. And we don't want to search too far. We want who are the established experts. And it's these people that we see visibly in the forefront. And that's how the choices are being made. And Black women are saying, but we have been working on these issues as well. Why are we constantly overlooked? Why is it that all the time it is the white women that have what my colleagues call interpretive mastery or interpretive authority over Black people's lives or Black women's lives? So we are the ones that speak of experience. We speak about what we go through. We are the victims. We are the perpetrators. We are the bystanders. But the person that comes in and makes sense of all this picture is a white person. So it becomes, we are objects of knowledge. Some people will say subjects of knowledge, but in decolonial thinking, it's objects of knowledge. So these are conversations about us, without us.
That actually brings me to my next question about why do you think it's important to center Black women's voices when we have discussions or when we discourse about sexual violence and sexual harassment and how we understand it in contemporary times?
The simple answer to that would be representativity, but it's not representativity where we're just looking to tick a box. It's more about our communities needing to see us as Black women, not just Black women, but Black men as well, and non-binary people, so that they see that we are having these discussions, we are engaging in these discussions. It's not just other people talking about us, and we're not simply importing ideas from abroad, which we are now trying to force on our people here. So we have to show them that these conversations are organic. We are growing them here. And can you also join us? Because when we just leave things the way they are, people will assume that Black women in particular are being influenced from the outside. That's why we see them as agents. You are not talking for yourself. This is not your voice. This is not your ideas. You are being influenced, or you are a puppet. So that's why we can have these conspiracies that you are bringing a Black man down. Yeah.
So it clearly would have been very impactful to have a Black woman as an expert witness in the context of these proceedings.
Yeah.
And when I listened to Nicolette speak about the predictability of these types of arguments coming up before, she referred to Clarence Thomas. You've also alluded to Zuma's trial as well. What do you think would have been useful about having a Black woman in these proceedings, if you can just think of that?
I wouldn't say just a Black woman. I think you need a team of people, team of people with various expertise so that we can help each other along. So Nompumelelo might be an expert on gender. I know the nomenclature. I know the theory, but somebody else might be more conversant in the cultural aspect. Somebody else might have more knowledge of a specific community. So we need teams of people to work together. This thing of one person must carry the whole burden, it doesn't really work. Yeah.
Okay. Now, in the context of that, you've written about how culture is being used as a trump card.
Yes.
It's almost like it's an additional requirement in this
Yes.
case,
Yes.
in the context of Black women. Now, in the tweets we've seen, or at least the people online have seen, this is something that has been employed elsewhere. Can you explain what you mean when you say culture is used as a trump card?
Well, on the surface of it, you see a deflection to say that, well, you know, this is behavior that is okay because my culture says it's okay. But when people use culture as a trump, what they are saying is, you have failed to take my culture into consideration. Now I am going to educate you. And because you have failed to take my culture into consideration, what I have to say about my culture surpasses and dispossesses whatever you are framing as violent. Yes.
So usually it's Black men who invoke this defense, if I can call it that, of culture, in the context particularly of sexual harassment and gender-based violence more broadly. What conditions do you think exist in our legal systems or even workplaces generally that enable the use and misuse of culture and allow it to now become this trump card?
Okay. In this instance, I have to explain where I'm coming from.
Okay.
Because I also will have to admit that there is a class privilege. So I come from a context where I was educated in historically white English liberal universities. So the culture there definitely was kind of a Western or Western-centric or Eurocentric one. So also when I went and looked into the documents, I was looking at rape law reform. So I looked at Project 107, sexual offenses, approached it as a historian, and you see the people who are giving inputs into the reform processes are people who have a very negative perception when it comes to Black cultures and African cultures in particular. So what I was picking up is that they're trying to find any and all means to keep it out of the conversation. Keep it out of the conversation because you're bringing these hodgepodge cultures, but our common law is clean, it's simple. Our Roman Dutch law is clean, it's simple, everybody knows it. So keep it out. And in fact, that is how you create the gap, which is what I was talking about. You have failed to consider my culture. Now I'm going to educate you about it. And I'm carrying my go-to book, The Kanga and the Kangaroo Court, by Maxilo Mutse. I hope I'm pronouncing it right because I've heard people calling her Machilo Mutse. So she actually talks about some of these issues, and she talks about the importance of culture and how it is left out of cases. So we do see Black men using it as a trump, but it's because prosecutions don't go into and investigate culture. So they don't utilize culture in a way that can be helpful for a complainant. And that is what is covered here, if you look.
I'm glad you've circled back to the significance of culture because of how emotive it is and how it resonates with people. So on the continent, we've seen how African cultural values have been weaponized against marginalized people like women, like queer persons. How do we begin to reclaim our culture in a way that is positively impactful in the law?
I think what needs to be done is to be intentional in our approach to culture. Don't let it come up incidentally. So put it, when you have your agenda, your reform agenda, have the culture there so that it is a topic that people must engage with and they cannot circle around it. In that way, you also invite different viewpoints on culture because we have different interpretations of culture. And we need to hear the diversity of voices about how we interpret things in culture. At the moment, the way culture is being put forward, it's always one-sided because it's on the side of the defendant. So what I am drawing on is mostly from the workplace as well, as somebody who has worked a little bit in the NGO world, but mostly in academia. What we need is to take less of a top-down approach. You don't go in there being taught. There's no conversation that happens up front at the onboarding stage about what sexual harassment is. What is the weight of culture and all of that. Those conversations should be happening at the beginning as people come in, and they should be constant. They should be happening all the time. But what is happening in organizations is that you wait until a problem happens. Then all of a sudden, now you hear about a policy for the first time, which was never discussed. It was never discussed. If you were lucky, you got a code of conduct thrown at you, was as born, you'll see yourself. Now the proverbial thesis has hit the fan. Now all of a sudden, now we are discussing policy. So we need less of a top-down approach. Bring people in to the making of policy. Let's put our cards on the table and let's discuss, let's compare. When we do that, then there is a space for us to also dispel certain myths. I remember when I was a student, I was a master's student, I had a classmate, a male classmate, and he was like, this sexual harassment thing, it's such a white thing. White people don't understand us. We Black people, we like to touch each other. And it's a normal thing. And I didn't know what to say to him. But when we create that space for these things to be discussed upfront, then myths like that, we can start addressing them. Rather than letting somebody linger with that misconception, we can address it there.
Thank you. Thank you for that, Bumi. Thank you also for that, Zetu. Now we will open the floor to everybody else who are panelists. But before I do that, I would just like to thank my fellow panelists for their lovely contributions. We were planning to play a video of some of the tribunal content from Mbenenge. I think it'll play for the people online, but the people in the room won't be able to see it on our screen. So maybe we can play that now as we invite the other panelists to come back on stage. Awesome. So people in the room, we'll have a roaming mic. Do you have any questions? People online as well? Oh, okay. We'll allow it to play. In the meantime, people in the room can start thinking of what questions they might have. about all of the content. Do the panelists maybe? Oh, yes. Would you like to begin? Are there any questions in the room or reflections? Okay, go ahead.
Think that I forgot, which actually connects to Zetu speaking about the manosphere. The other reason why we need to center Black women and Black people, it's to address what I see as this growing gender schism in the Black community. And we see this with the rise of the manosphere. And also this growing thing that, you know, we routinely make false accusations against Black men. We saw it with the case of Sjava, Jablan Hadeb. The case, it didn't go forward. So now we assume that Lady Zama was lying. We saw it with Tall Esmo, Monyezi Mahlangu, when he was accused by the Ratumuroi. Well, we don't know what happened between them. And then there was Ubafana Sitole, the schoolboy, who committed suicide after a schoolmate joked that he had raped her. So he committed suicide. And these are the things that we can actually start addressing once we have the platform as Black women, Black men, and non-binary people to address these concerns and talk to them directly in our community.
When you were talking about the choice of expert in the Mbenenge Tribunal, you talk about the invisibility, so not putting it up front, that it creates this opportunity for the judge to say, let me tell you what culture, you know, is. When I listened to it, I also saw it as something that makes it easier to challenge the expert's witness. Because it's one thing to say, let me close the gap, but it's another to say, to discredit the expert now. You actually don't know what you're talking about, because have you ever been a Black woman? Yeah. You know, do you know how Black people actually talk to each other? You know, so your evidence actually has got no weight. It's acontextual, you know, it doesn't. So you are talking about power in abstract. And once again, on intersectional discrimination, what it does, it then weakens her defense, not her claim, you know, that she was subjected to sexual harassment, because the power analysis that we can agree with is now being challenged, you know, on the basis of you actually do not know. So it basically plays into the hands, you know, of the patriarchs and the misogynists who are seeing this person as a decolonial hero, you know, to say, go out there, actually don't just educate her, but actually tell her that what she's saying, she actually doesn't know what she's talking about. Yeah. You know, this is Greek, you know, to her. What also makes it worse is in a context like ours, where we live with a very visible and permanent scar of racial discrimination, is here we go with the hypersexualization of Black men. So you have come here once again to diagnose me of violence, right? And that's why he is able to get this public sympathy, you know, to say, tell them, you know, because they keep on saying that we are the perverts, you know, we are the people who commit all of this violence. And so the claim or the defense becomes so easy to accept that this is something that we don't understand. And in fact, it's not only the weakening of the claim, but it also allows other people who see themselves as racial champions, including white women, right? Because in this conversation, there are a number of white women. You have the expert in this case, Lisa Verton, but on social media and elsewhere, you had Gillian Skirt, who was coming in to also basically line up next to Mbenenge and saying, tell them, like me, I am an educated white, who actually understand, what you are talking about. So you still have the Black women's voices not really being part of it, because in the public, there were very like three kind of voices, right? Because the other one was the Daily Maverick, and all of them. And so these are people who were talking and writing about this issue quite consistently. And so you see the erasure and the invisibility sort of coming in. So that's what I just wanted to kind of contribute about the meanings of having the expert in the room that looks like this. And also the composition of this tribunal, like just the race and gender. Because a Black woman who is there permanently is the stenographer, is the interpreter, right? The tribunal doesn't have a Black woman, right? And the defense has got two Black men. The evidence leader is a white woman, right? And so Black women are coming into this tribunal as the witnesses, as the complainant. And that's such an unfortunate, like choice kind of all around, because this is how race and gender continue to play in itself, because people will say, no, we just went based on expertise, it's your witnesses, like everyone that you are choosing in this particular case basically forces to have a tribunal that has a Black woman sitting there by herself. Yeah. And not, because we talk about representation, but not anyone, like not being represented in the tribunal, not being represented in the legal representation. And yeah.
Thank you, Sibongile, for those reflections. I'm going to open it again to the floor. Are there any questions? Are there questions online, perhaps? Our women in STEM are helping us online. Thank you. There's one question. Can you come to the front so the people online can see you? Thanks, Vitu. You can introduce yourself. Here's the camera. You are dressed well.
Okay, hi everyone. I'm Vitu from Malawi. I think my question is to Nicolette. I was very intrigued about the evidential issues that we have, especially in sexual harassment claims. Now, my question is, particularly in cases where maybe you're litigating either before an employment tribunal or some other court that you're at, how do you tactically navigate around the evidential issues that either try to discredit the witness or some other barriers that are existent in the law when it comes to the issue of admissibility of evidence? Thank you.
Thanks.
Thank you for that question. And I think that what's different in this tribunal that we're dealing with here, it's an inquisitorial process. And so they sort of asking questions. It's not a court process. But the Code of Good Practice on Sexual Harassment has really tried to lay out in terms of some of the common challenges that come up, because before, and our Labour Appeal Court is also pronounced on this, like the issue of similar fact evidence. Similar fact evidence is normally regarded as inadmissible. But our Labour Appeal Court has said in sexual harassment cases, it's really relevant to take into account patterns of behavior by perpetrators with other women, and it can be allowed. But that was a specific challenge that had to be brought and go all the way to the Labour Appeal Court to deal with that evidentiary issue. What concerns me in recent cases has been this issue around credibility, how the courts grapple with credibility. And I think we need to interrogate how different judges and different arbitrators and commissioners have taken completely different approaches on the same set of facts on credibility. And because in sexual harassment cases, it's always going to be he said, she said. And so the Labour Appeal Court has consistently said that we need to be training commissioners, we need to, and has slapped the Labour Court on its knuckles saying, we need to apply the correct test. You need to start looking not the poor perpetrator. The poor perpetrator didn't know what he was doing was wrong. You have to approach it from a survivor-centered approach. And that language is now much clearer in the Code of Good Practice. What does a victim-centered, a survivor-centered approach look like in terms of approaching it from the perspective of the complainant? But I worry in terms of what has come up of the panel today around how we interpret complainants' behavior and complainants' actions and how weight gets attached to. And there's assumptions and bias that comes in terms of our race analysis and our class analysis. And this trend of the intellectual, well-spoken judge, and this came up in the case involving cleaners that were not consistent. They've changed their story, and then jumping to the conclusion that you're lying. And the Labour Appeal Court, we have to be very careful about how we interpret and take into account power dynamics, how people explain themselves, how people talk. And so I think this, the credibility issue is a big issue that's coming up, and how we think about the weight that you attach to evidence. Our court has said you can't attach a lot of weight to the fact that someone laughed or accepted compliments, went on a dinner date, perhaps, because there's a power dynamic. And so the courts have said when we look at evidence, we have to constantly do a power analysis of what's actually going on here when someone replies with a laugh emoji. That doesn't mean that it's not sexual harassment. We have to really understand the dynamics at play. And I don't think all our courts are doing that consistently. There's some very problematic judgments, and I don't want what I'm saying here to make it sound like, oh, the Labour Appeal Court gets this right. This inconsistency of approach says there's more work for us to do in terms of how we present evidence, how we bring experts to the fore, and how we constantly make the intersectional argument and a race, class and gender analysis to the arguments.
So before we close, I just wanted to raise an important factual issue as well. So before this incident of Mbenenge, there wasn't really a policy in the judiciary that was regulating sexual harassment. It was only introduced quite recently. I think it was on the 9th of August in commemoration of Women's Day. So it's quite a novel policy that's been introduced. Even this Judicial Conduct Tribunal is very also novel as well. It's the first time it's sat in such a manner. And it's sitting to discuss the vexed issue of potential sexual harassment in the context of gross misconduct. So even the courts themselves, who are also employers, are failing to create a work environment that is conducive to women's rights and protection against sexual harassment.
I mean,
Sure, let me give you the mic.
I think the fact whether there's a policy in place or not, you still have your duties as an employer, your common law duties, your constitutional duties to protect the dignity and equality of people. But I think this perception in our minds that judges are somehow like the corridors of the judiciary, nothing bad can happen there. And I think we saw this with the Motata Judicial Conduct Inquiry into drunk driving and his behavior there. And I think this notion that we don't hold judges accountable or judges are, above the law, that was a myth that came up quite early in this tribunal that we have to address. And I think that speaks to why there haven't been policies in place. It's like we all know how to behave. These things can't happen in our corridors, which also speaks to power to me in terms of how we're seeing the role of the judiciary and the duties of the judiciary or people in positions of authority. Zethu.
No, but I think we speak about patterns, but this is a pattern that his secretary comes out and says, but this is something that he does, right? And she then defends him and says, no, but he's joking. Like he does it with lawyers who walk in and says, and he comments on how they're dressed, right? He also comments on how I'm dressed. So this is not something that they are seeing as problematic, right? So why is now, it's being then framed as she is the one who doesn't understand his behavior. This is something that has always been there. This is the culture. This is how we do things. This is who he is, right? So he is also being defended. And so this notion of it being a pattern, it is there. The evidence is there. It's constantly being repeated that he did not take her no, right? He's not being framed as a man who did not, who could not respect her, no, but instead it is seen as a man who is pursuing a relationship. He's seen as a man who is playful, who is joking, right? He is seen as this charismatic man, and this is how he's constantly being portrayed. And all of this is not seen as violence, right? And so because it is not physical violence, it is not something that you can hold on to and say, okay, these are the scars that I have from this. Whether you are uncomfortable by the comment or not, that doesn't matter. So this behavior then becomes a thing of, this is just who he is.
That's such a good point. There's a decision involving Nedbank from 2 weeks ago. The Labour Court dealt with this, where you had a manager where he brought witnesses. He brought lots of witnesses and other secretaries who said, he compliments us and it's fine. We don't mind. And men came forward. He had a long list of witnesses who said he compliments us on the way we dress and we don't mind. This is like gender neutral. He's often commenting on how people dress. And the evidence about her was she hates men. She was heard in the kitchen saying men are pigs. This is a vendetta against all men. And the CCMA commissioner said, she's not credible, she's lying, this is a vendetta. I accept the other version because of all these witnesses that were brought. And Nedbank, to Nedbank's credit, took it on review and said, we've dismissed this guy and he's challenging his dismissal, saying this wasn't sexual harassment, this is the way I behave, and she's on a personal vendetta against me. And the court actually, a very good judgment, speaks about this power dynamic and saying the fact that others come, that evidence was actually irrelevant. Because you have to look at how she felt, and she felt uncomfortable by being touched and these compliments and rubbing of her shoulders. She was uncomfortable, and that's the test subjectively in terms of what she said. And you can't say that her credibility, the fact that she said men are dogs or men are pigs, was then held against her, that she's some feminist that's against all men in the workplace. And even the women that testified against her, saying she's just being prudish, she's being hysterical, she's being difficult. So I worry about this kind of narrative, but the judgment there actually said that was all irrelevant. And we have to look at it very subjectively in terms of how this plays out for the specific complainant. But this victim blaming and shaming, it's not going away anytime soon. And we're now in a position where we have to rely on employers to go on review or take it further. And so there's the silencing effect where we actually just we're silencing women and we're rendering the issue completely invisible when this kind of thing happens, where men can just round up other witnesses to come forward and say, but I was okay with it.
Okay, I wasn't going to say anything, but what comes to the fore for me as a political scientist is the weight and the political significance of this particular case. You've mentioned that the policy hasn't been around for judges, and so for the public it would look like, okay, this is the first time that a judge is being taken to task, and it's happening at this juncture of our democracy. Surely he's not the only judge who has ever done things like this. These things have to have been happening before, and they have to have been happening during apartheid. And so a Black man becomes the casualty of democracy. We have to consider that that's what the public is interpreting as well. A Black man is becoming the casualty of democracy.
Yep. I think when it comes to the creation of an enabling environment to address sexual harassment claims, one of the things that comes up in most of these cases, and this is in the jurisprudence on gender-based violence cases in the Constitutional Court, you see that there is a very particular way in which Black women show up. And that is when, and I think in the sexual harassment cases as well, where you have an employer or someone who's trying to defend, you know, themselves, and then saying this law should not have been used or is unconstitutional. So there are very few cases on gender-based violence where Black women are the claimants who are going to court to assert, you know, their rights. And so we usually talk about this as a product of legal empowerment and access to justice very broadly, not being able to take these cases forward. And that's why in this case, there's an issue of courage, you know, when someone who is said about this policy that's coming in the judiciary, because for as long as access to justice is a challenge, and some of the challenges is not just the financial, you know, aspect of it. Many women are scared to bring these claims forward because of the vitriol that they have to, because it really takes a lot to go and complain against a person who is known, respected, and just who has a lot of power. Now, we have seen this public interest standing, you know, where the employer says, I have an obligation to create a certain culture, you know, in this organization. So I am going to take these disciplinary steps, you know, in order to bring order, you know, in this organization. So I don't want anyone to be discriminated in the workplace, and that's what I'm going to do. And at the beginning of the year, around about the time when this tribunal was standing, something very scary did happen in this country. That the Legal Practice Council tried to institute proceedings against a legal practitioner, Advocate Dalimpofu, and one of the charges was around sexual innuendo against the Chief Justice. So she was not a complainant. And they were saying what happened was when she was being interviewed to be Chief Justice, this advocate who was there made the sexual innuendo by saying that I have spent a night with the candidate, meaning the current Chief Justice. But what was interesting, because these are the things that we want to see, a regulatory body saying we don't want to have lawyers who behave in this way, calling out that behavior and saying that it is inappropriate for someone to behave like that in that space, because this is during the Judicial Services Commission. These are interviews for the highest judicial kind of office in the land. And these are the kind of Legal Professions Council. And who was not shocked by the Chief Justice's response. You know, at that time, because she refused to participate. Yes. So you have said this, Nikki, when we were talking about this, that the person who is a victim of the harassment must actually, for them, they have to feel that the conduct is offensive. The Chief Justice did not say anything whether she found it offensive or not offensive, but she took the position that this was chivalrous, you know, of the NGO that had lodged the complaint, and also for the Legal Professions Council to take on this case, you know, about that. Legally, and in terms of access to justice and what was trying to do, what was the problem with that kind of response to that action that was taken by the Legal Professions Council?
Well, I think I want to complicate this issue because at the one hand, you have the issue around agency and the agency of complainants to come forward and take and speak in their own voice and in their own name and not be rendered invisible. On the other hand, in employment context, the law has been clear, and I used the example earlier that if I say, look, I like it when my boss massages my shoulders, or I like it when my boss hits me on my behind, the employer can still say, okay, you don't want to lodge a complaint, but as employer, we're going to say there's a standard and a code of conduct in terms of what is and this is the point you were raising. It's not about what's written in a policy, but what is the culture that we want to create in our institutions, in our workplaces, in our judiciary? And so this was a moment for us to say, what is the culture we want to create? And so the legal practice, by them saying we want to take this on because we want to create a culture in the Judicial Services Commission when interviews are conducted, I think that was a right approach to say, what is the culture we want to create? Can we have a conversation around this? And the fact that one person, because I think this is always going to come up, we've touched on it earlier, what one woman finds offensive, another woman may find okay. It's not monolithic. What one black woman finds offensive, another black woman may find that it's okay. And this is where that conversation around what are the standards that we want to create needs to be taken into account. And we have had many cases where the complainant herself isn't making the case. The employer is taking on the case. And we've got one case where the husband of a complainant lodged a grievance around sexual harassment, not his wife himself. And it raises all kinds of issues around agency and invisibility of complainants and how employers then conduct themselves. But I think that was a missed opportunity for us to open up a conversation around what this conduct looks like.
I mean, I think it was a missed opportunity to send those signals, you know, that under this leadership with a new policy that is coming up, that these are the signal that this kind of behavior is not accepted, you know, and acceptable in the judiciary. And so, and it's one thing to talk about agency, that I should have been the one who lodged this complaint. But I think it went too far to say that this was chivalrous, because this is what we are asking for. Because what it did was it delegitimized, you know, this action of NGOs coming forward and also the Legal Professions Council saying, we have to send this message, because we have been fighting for this to say, even if there is no complainant, because this happened in the public sphere, that's what you are addressing. The thing that you are talking about is the conduct. Because if the conduct is left unaddressed because people are unwilling to go forward and other people are just fearful, then it becomes normalized, because the manosphere and the misogyny that actually threatens women stays winning, because there is no one, even in the public interest, who can actually go forward and take these claims, you know.
We have a comment or a question. Sena, I'm going to have to read it out on my phone once I get the photo. Okay. So Goratsa Chengeta says, thanks for this important panel. My question is, are there any initiatives that can prepare Black women from different sectors to prepare to serve as expert witnesses in legal tribunals? Having seen the line of questioning that the expert witness was subjected to, it seems that while you have some expertise, the legalistic process of cross-examination by the defense is quite brutal, and legal preparation would be helpful. There's also another comment or question from Osai Ojigo. They say this intersection of grace and illusion of expertise is critical. In the ICC case of Lubanga, it also plays out when one of the experts in his defense was a white woman, arguing that the court take into consideration his history as a former child soldier to reduce his culpability for SGBV. Culture was also cited in his defense. Is there something there about how we can get more Black women and lawyers with lived experience to publish more to challenge these negative stereotypes about competence and expertise?
Okay. So thanks for that. I'll start with the first one. In litigation, there aren't a number of people who like to be expert witnesses because cross-examination is not a way of uncovering the truth. It's basically a way of discrediting, the other side. And Zetu, I think you were reading Advocate Ngalana's kind of blog, him saying that there's actually nothing wrong with what the defense is doing because that's their work. That's how it actually works. You may see it as being brutal or as being violent, but that's the nature of cross-examination. Interestingly, in this complaint against Dalim Pofu, it wasn't only what he did to the Chief Justice that was an issue, but it was his way of cross-examining a former public protector who also refused to be part of this case, citing similar reasons, right? That she was not consulted, and therefore, how dare the Legal Professions Council actually goes ahead with this. So whilst on one level, we continue to see the styles of cross-examination that makes experts, especially people who do not have expertise, because in the Mbenenge Tribunal, we are aware that quite a number of people were asked to be experts and they were not available for a number of reasons, including conflict of interest, or people just feeling that for this kind of case, I may not be the right kind of expert. So, Khoreka, there is quite a lot of work that needs to be done, not only for people who are surfacing race, and gender or culture, but to get experts who are going to testify about sexual violence broadly. But it is deliberate that cross-examination makes it not attractive, for them. And so a part of the work for people who are doing strategic litigation and whose work requires them to provide experts to actually invest in this line, of work. Because sometimes people know what they know, but the fear is, I don't know the law. So this is not where I actually need to go. It happened, Nikki and I, over 20 years ago, worked at the Women's Legal Center. And we had this when it came to psychologists. So we ended up using kind of the same kind of psychologists over and over again, because many of them, were fearful. So it is something that all of us recognize because there is a high price, and our clients are the people who are paying that price. And that's the thing that we actually need to be investing in so that the quality of justice that Black women receive is not affected.
I'll just add to this that
This tribunal is meant to be, we have an adversarial legal system, and I think it's been critiqued a lot in terms of how it plays out in sexual violence cases and GBV cases, because that adversarial cases, there's a winner, there's a loser, there's a attack on credibility of witnesses, versus an inquisitorial system, which is meant to be, this is an inquiry into uncovering what happened, and there's a lot of asking of questions, but it's not about attacking the credibility. So it's a less adversarial approach. The tribunal was meant to be seen as an inquisitorial tribunal, but the way it's playing out is like a court, which I think we need to address, because there was a reason why we say, oh, this tribunal is an inquisitorial approach. And I think Rashida Manju deals with this quite a lot in the equal education sexual harassment case, around inquisitorial approaches versus adversarial approaches. And our courts have pronounced on the fact that cross-examination is never meant to impair the dignity of witnesses. It's not about impairing dignity. It's about a ventilation of the dispute. It is going to be about asking hard questions, but you're not meant to impair the dignity, particularly in sexual violence cases. And I'm sad to say this is a global phenomenon in terms of how cross-examination plays out in many, many parts of the world in terms of the attack on the credibility of complainants. But this tribunal is not meant to play out as a court of law, but it's following all the rituals of a court, which I think needs to be unpacked in terms of how even the complainant has been addressed and dealt with.
We also need to address this issue of hierarchies of knowledge. In terms of legal professionals, the legal fraternity, there is an uneasy, or what I sense is an uneasy relationship with other disciplines and other knowledges. And when I was doing my research, it seemed that there were questions around, well, do we really need experts? And how far should we go in terms of expertise? So there is a suspicion of experts. There's only a few kind of experts that are trusted by legal professionals. It seems doctors, there was even talk of an incentive for these high status experts to be part of such proceedings. So it's forensic people, it's doctors, but the rest of us who are in the lower rungs of the social sciences, it seems that you don't know how to interact with us. You don't know what we bring to the table. And I don't know how that is something that you can talk about and we can come to an agreement about, you know, this is the basis of the expertise and that's how we're going to use you. That has not been resolved. It's an open question. Even social workers, I mean, social workers are part of the criminal justice system. They are leaned on quite a bit, but they were even complaining that there's no regard for us. We are not respected in this whole thing. You don't understand our expertise. You don't even see our importance. So that's definitely something which I feel that the legal fraternity needs to open that question and decide. Also in terms of experiential knowledge, in terms of knowledge of communities, because it has come up that communities have their own knowledge systems.
Yes.
How do you engage with those knowledge systems, which are grassroots or local knowledges? Of course.
Also, I think there's also a heavy reliance on Western ideas of knowledge, right? So lived experience is not seen as a form of knowledge, whereas the best expert on anything is someone who has the lived experience, right? And so for as long as we constantly put Western forms of knowledge at the forefront, and when we're looking for experts, we are always going to have this issue of who is an expert and who is seen as not, because by virtue of you having a lived experience, there's a certain amount of knowledge that you have on the issue, right? And so this is also why when I was writing my master's and I was writing from an autoethnography, it was pushed back a lot from the law department, because they were just like, what do you know? How are you substantiating this? We need you to come up with evidence, with proof, substantiate what you're saying, right? And because the court is not an issue, it's not a proceeding about truth, they're wanting to, what can be proven? What can be proven beyond reasonable doubt? There's a standard that exists. And so for as long as those standards and things are still put in place, our lived experiences are always going to be sidelined. They are always going to be put on the side and not seen as important and not seen as, okay, no, these are people who can come into the space. And this is why then we will still have this issue.
So Osai's question is about the need for people to publish more so that we are able to surface. And I'm going to add that maybe we need to go a little bit further. We don't have a lot in the body of law. So one, we haven't developed the jurisprudence. I mean, intersectional discrimination is something that comes more than 3 decades ago. You know, the 1989, I think that's when the debinationalization was published. So we haven't developed remedies for intersectional discrimination. So when someone faces intersectional discrimination, that's missing. We haven't found, you know, people guilty, or we haven't found claims that are based on intersectional discrimination, you know, succeed. And also we haven't really framed a lot of cases in a way that raises this. So when it comes to jurisprudence, we know that we haven't done well. And perhaps what we need to do is the development of normative standards, you know, that recognizes the intersection, you know. We had a missed opportunity. In February of 2025, the African Union adopted a new convention on the elimination of violence against women and girls. It's the most shambolic treaty I have ever seen in my entire life. And if you want to see, is what it does in Article 7, which is an article that purports to deal with intersectionality. Other than just me listing a whole range of grounds, it fails to establish what obligations are there for states. But more than anything else, it actually fails to even define, you know, what intersectionality is. But the worst is that it purports to be intersectionality, but it doesn't have race as one of the grounds, you know, in dealing with intersectional discrimination. And so the lesson here is really about, if we want to have treaties and laws that protect people from violations that we see and the law is still not able to respond to, we need to be intentional, you know, about it. So I'm saying we need to go beyond just publishing, but to get the law to really surface how this happens and also what we'll need to do in order to remedy it.
Thank you, Sibongile. There's just one more comment and question from online, and it reads as follows. It's from Busisiwe Aland. It says, thank you, ladies, for a powerful conversation. In light of the Mbenenge case, how do we, as a collective, critically confront the deeply disturbing perception that Black women are readily available and thus unrapeable? What does this reveal about the intersection of race, gender, and power in our legal and societal structures? And how might we begin to dismantle the systemic failures that continue to deny Black women full protection, dignity, and justice?
I know. And you ask for solutions.
Make us readable.
I mean, I think there is something that, I don't know, it feels so much bigger than just one solution, right? There isn't just one way of doing it. We can't just say, okay, we start in the courts, we dismantle, because this lives in public imagination as well, right? It lives in our society. This is why then this concept of it being brought up in culture is also then a thing, because it exists in so many different spheres. So how then do we go about whether it's teaching it from school, from a young age, right, into it being taught then at, in the laws, where do we start, right? Because this is a societal issue. And I think this is something that I grapple with so many times where I'm just like, where do we begin, right? And so my research then begins in the trial and with the law specifically, because that is the space in which I am learned in and I understand. But it is bigger than just the law. And so it is a bigger issue than just taking it apart and saying, okay, we are now going to be seen as rapeable, right? But or violence against us to be seen as not normal, right? Because we live in a country where the violence against women is normal, where it's seen as, oh, the post Women for Change, this is a thing that we see on a daily basis. We have become so desensitized to violence that it is not even something that we now know how to deal with or how to navigate. So there is a dismantling that needs to start from the fiber of our society. It needs to go deeper than just the law. So I think this is a huge question. But it is something that we are working towards, that we are trying to reimagine different ways, to think of alternative ways, right? But it also needs to be something that is done collectively, right? It is not an individual struggle. It is not something that I alone can do, or just because this is the sphere that I'm interested in. It is a collective issue. And I feel that that is where we begin, when we start seeing these issues as collective and not just individualized. I think once something about this tribunal is that it has placed Ms. Mbenenge as an individual victim, whereas this is something that exists on a daily basis that we encounter all the time, right? But now it is her being separated from everyone. And it is now even that the fact that even I think it is intentional that there are no experts that look like her, that there are no people around her that look like her, right? It is this way of the law to isolate, to remind the victim that you are actually on your own. And it is a way to quieten victims. And it is a form of violence that exists. And I think it is very intentional. But yeah.
Just quickly, I think I agree fully. Irrespective of the outcome of this tribunal, I think there needs to be an interrogation of how this played out, with Black women speaking about all the different permutations of what happened here, from the intersectional analysis, from the expert witness, from the manner in which the complainant was dealt with, both inside the tribunal and outside the tribunal, because it's a reflection on where society is at. And so there needs to be like multiple strategies. And I just want to acknowledge the radical bravery of the complainant. It takes so much to do this. We need people to come forward. And when people come forward, what are we doing to have their backs? And so what does that collective embrace look like to show what radical solidarity looks like in the face of radical courage? And so I worry that not to invisibilize the complainant even more. And so irrespective of the outcome, how do we practice that radical solidarity and really interrogate and unpack what happened? So even if there's a good outcome, what happened there, there's an indictment on all of us around what happened. And how do we come together as Black women to speak about what happened from a place of authority and from a place of lived experience? And we need more cases like this. But no one, I wouldn't want to come forward. When I sat there and listened to that, it was shocking what played out there. And so we can all be shocked, but what does it look like then to actually hold? And if I think of, I was reading Anita Hill's book, 30 years later, grappling with what she went through and how she was vilified as a Black woman for taking down another Black man. She said it didn't happen overnight. The apology came last year from Joe Biden and from members of that committee to how they treated her, and how there has been no public apology for how she was treated. And so I think that dynamic, how that plays out, how can we step forward much quicker to do the public apology and to acknowledge the radical bravery and show solidarity, irrespective of what happens.
Thank you, Nicolette. Just to recognize one more time the courage of the complainant, but also the courage of her legal team who brought this case. She was represented by the Women's Legal Center in difficult circumstances, as you pointed out, Nicolette. And this tribunal will have its closing arguments later in the course of this month. But as you have seen today, we have started the conversation of interrogating where our law leaves us as Black women. And this is just a starting point. We hope to have more discussions like this in similar fora. ISLA Conversations are ongoing discussions that we have periodically, so please look out for them. I have one last thing to do, which is to thank all of my panelists, Nicolette, Mpumi, Zetu, and then, of course, to thank my co-moderator, Sibongile. Thank you for carrying us. And then my women in STEM at the back, aka our photographer, everyone else who's assisted, as well as you participants from the Feminist Litigation Network who are here in person. And then, of course, our people online. Thank you all for joining us this afternoon.